Good evening. Again, I'm Nathaniel Parker. I've been retained by Borough Council to assist them in negotiating an oil and gas lease, advising them on the terms. I've been asked to go through the terms of the lease, and I'll start and go through them in order. Before I start, just in general, this is a lease, it's not a sale. An oil and gas lease is generally temporary in nature for an initial term, generally in months or years, and then if oil and gas production is established, then it goes on indefinitely. That's the nature of all oil and gas leases in Pennsylvania, and the lease that I'll go over is consistent with that. So beginning in paragraph 1, it describes, together with the Exhibit A attached, it describes the property being leased, which is situated in Ford City Borough, Cadogan Manor, and North Buffalo Townships, Armstrong County. It lists the different parcel numbers for an aggregate acreage of 313.972 acres. Exhibit A on the back lists different tracts, including the numbers in the orange. The lease is for all the oil and gas on the property. It's not a particular formation or subset. Paragraph 2 specifies the drilling rights. It is quite lengthy, and in general, it gives the operating company, in this case Snyder Brothers Incorporated, the right to effectively do what they need to do to operate for and extract the gas from the property. That's paragraph 2. Paragraph 3 is the lease term. The lease term, the primary term is for 10 years, and as long thereafter, as I indicated, as oil and gas might be produced. Paragraph 4 kind of piggybacks on 3. It is a right of extension or renewal. The 10-year primary term can be extended for another 10-year primary term without the production of gas. In order to do that, there must be a bonus payment that we'll go over in a minute. We haven't got that paragraph yet. Paragraph 5 explains what's called the unitization rights. Unitization is where the operator operates multiple tracts together as part of one ongoing enterprise. So you'd have one well or well pad, sometimes multiple wells from one pad that impact on multiple properties. In this case, the size of the unit is capped at 1,280 acres, and all land must be contiguous. It also specifies that if the property is unitized, which it most likely would be if it was developed, the borough would receive a proportionate amount of the royalties from the well, and the proportion would be directly related to the number of acres that the borough owns that is included in the unit as it relates to the total size of the unit. Paragraph 6 talks about existing wells. If there are existing wells on the property, this requires the Ford City to offer those wells to Snyder Brothers before they would offer the wells to a third party. Paragraph 7 defines the royalty, which is the remuneration that Ford City would receive if oil and gas is found on the property. And in this case, in this lease, the royalty is divided into 2 parts for gas production, oil production from shallow formations, from the surface. Between the surface and the top of the Tully limestone formation, it's 12.5%. And for the deeper formations, it's 15%. It is a it's a net royalty. In other words, there are deductions, taxes, reasonable costs incurred by the lessee, depending on the location and the quality of gas that comes out of the ground. Next paragraph, paragraph 8, this is the bonus payment, and the bonus payment under this lease is $100 per leased acre, payable within 120 days of the effective date of the lease. So that is the payment that would be required at the beginning, the first 10-year term, and it would also be required if the second 10-year term option is picked up by a company. They would then pay that again in 10 years to extend for the second 10-year term. Next paragraph is shut-in royalty. What shut-in royalty provides is it's a mechanism by which the company pays a certain amount of money, in this case $10 per acre, to the landowner lessor, Ford City, in the event that the well is capable of producing but is not producing for various reasons. This amount of money would be paid. It would be non-recoupable by the gas company unless the well is shut in because of the drilling or fracturing of a well on a pad that the borough property is included, in which case then the money would be recoupable. Paragraph 10 is very brief. It just describes that the royalties would be paid to the address listed in the lease above. Paragraph 11 is a force majeure clause. Force majeure, I believe, is of French origin, and it effectively means that if there's a force or effect that precludes a company from operating beyond its control, they would be excused from operating for that period of time. And then once the force majeure is removed, they would resume operations. Paragraph 12 is cloud on title. Similar concept, different cause. In this case, it would be if there's a title defect or an issue with the borough's title to the oil and gas, then again the company would have certain rights to delay its operations until the cloud on title is removed. Paragraph, the next paragraph is surrender, and it provides, and this is a kind of a standard boilerplate clause, the company can surrender the lease whenever it so chooses. Paragraph 15, notices. It requires the borough as the lessor to give notice via certified mail of any alleged breach. The next paragraph, paragraph 16, drilling permits. Ford City agrees to execute documentation that may be requested from time to time by the operator in order to exercise its drilling rights. Paragraph 17, the next paragraph, is what's called in the legal terms an integration clause. What that means is that the entire contract is set forth in the four corners of this instrument, and there's no other oral promises, representations, etc. that either party is relying on. It also provides that there would be no external rights implied or inferred in the contract. Paragraph 18, conveyance of property. This describes how the gas company will transfer royalties if Ford City were to sell the property to a third party. And it requires whoever that third party is to provide a certified copy of the recorded instruments before the gas company would be required to tender payments accordingly. Next paragraph down, it's got a complicated name, it's paragraph 19, but effectively what it provides is that if there's a dispute or a cloud on title disputing competing claims to the royalties, the gas company can put those royalties in escrow until the dispute is resolved, and by putting the money in escrow, that's like tendering to the landowner. So it again provides assurance to the company that their lease wouldn't be terminated because there's a dispute between different landowners. Paragraph 20 is another basic legal clause called counterparts. It means that the document can be executed in multiple copies, but put together they form one legal document. Paragraph 22, affidavit of non-production. The Ford City in this paragraph is asked to warrant that it is not currently receiving any bonus, production royalty, or shut-in royalty as a result of any prior oil and gas lease or agreement covering the property. Next paragraph, covenant of quiet enjoyment. Ford City is warranting title to the property only from and after the date of this lease. Ford City is making no warranty at all as to past title defects predating this lease. Next paragraph, almost there. Indemnity provides that the gas company indemnifies Ford City from any claims arising from the gas company's exercise of its drilling rights. Next paragraph, additional terms. The gas company has agreed in this case that it will not conduct any operations on the surface of the property without Ford City's prior written consent, which can be withheld at Ford City's direction for any reason. The only exception to that is geological or geophysical surveys. And then the last paragraph of the lease, 26, provides that this document is binding on its heirs and successors and can be assigned by any party in whole or in part. So that would be and then it ends with Exhibit A at the back. So that's an overview of the lease. Is there questions from council? I assume Carol's at the next step?
Yes.
Is there any questions for me about the explanation of the terms?
Questions?
Would you say, number one, in your experience,
I can't hear him.
Please use the.
Mr. Parker, do you believe in your experience working with gas leases, that this lease is advantageous to the citizens of Ford City Borough?
In the current climate, yes, I do.
Now, does this hold us, you now have rights to the surface gas, the Marcellus gas, and the Utica gas. Is that correct?
I don't understand your question. You said you're not talking about me.
Well, no, you're the Snyder Corporation.
You're asking me what gas rights the Snyder brothers get if this lease is signed?
Yes.
It would be all gas. Paragraph 1 says all gas.
So that means the surface gas, the Marcellus, and if it is true that this Utica gas is bountiful, then they have access to the Utica gas too.
Correct. I'm not aware of gas actually on the surface. Gas will go up in the air. So natural gas is below the ground, but it would be all shallow and deep. If that's what you mean, shallow formations and deep, it would be both. So that would include the formations that people hear about in the news now, together with formations that maybe they find 10 years down the road.
If I might just interject, if they are going to do the shallow gas, that would mean they would have to drill a well on the surface, which we have taken that right away. Is that correct?
In most cases, yes. Typically, the majority of shallow wells, the overwhelming majority of shallow wells are drilled via vertical well bores, drilled on the surface. They're not the horizontal wells that you hear about from Marcellus or Utica. So if somebody were to develop a technology to access shallow gas via horizontal from another property, then theoretically they could, but they could not drill from the surface of this tract without your approval that you could give or withhold at your discretion.
Okay. Go ahead, Mark.
And to research these leases and who owes the mineral rights, who has to pay for this? The citizens of the borough or?
No, Snyder Brothers. Snyder, but how it works with paragraph 8, the bonus payment, they have 120 days to pay the bonus payment. Typically, standard in the industry is that's when they would do their title. They're not going to spend money on the title until they know they have a lease. So step 1 would be for a landowner to sign the lease. After they sign the lease, then the company does its due diligence, does a title search, and then they would pay, assuming that they still want to exercise the lease, they would have to pay before the end of 120 days. Or notify you of some title defect or title issue. In which case, whenever that defect is removed, then they would pay. But those costs are borne by them.
And that means the cloud on title search too.
I'm sorry, what?
Cloud on title? The cloud on title,
That paragraph?
yes.
What about it?
12, that means that's beholden on the corporation to search this if there's a cloud on title.
It's up to them to determine that, correct? If they're not comfortable with the title, they either walk away and don't pay anything, or they could notify the borough and then work together to try to remove the cloud.